Last night, a man charged through a security checkpoint at the White House Correspondents Dinner with a shotgun, a handgun, and a variety of knives. He allegedly fired multiple shots, and Secret Service tackled him and took him down. The president, first lady, vice president, and over half of the cabinet, as well as 2,600 other people, including journalists and celebrities, all evacuated, some with fake tears. One officer took a round to the vest. He's okay. And nobody else was hit. The suspect is in custody. His name is out there, Cole Allen, and his address is out there as well in Torrance, California. The FBI swarmed his apartment in Torrance, California before the dessert course was cleared. Now, here's the part that caught my ear. Every major outlet this morning, CBS, ABC, Fox, CNN, all of them reported the same line. Law enforcement has his phone and his electronics, and they're obtaining search warrants to go through them. A federal judge in the Central District of California is expected to sign off on the warrants. It could take several hours. Several hours? How inconvenient. Because here's what none of the reports mention. They don't actually need a warrant for most of his digital life. Not for the stuff that lives in the cloud. His Gmail, his Google Drive, his iCloud photos, his social media DMs, whatever he had stored on Dropbox, OneDrive, any American cloud service. There's a law that was passed in 2018, tucked inside a spending bill, debated by almost nobody, called the Cloud Act. Under the Cloud Act, the government can compel any American tech company to hand over your stored data with a legal demand that's significantly easier to get than a warrant for your physical phone. The phone warrant? That's theater. I don't mean it's fake, it's real. They actually need it to get the physical device. But the data that's in the cloud, what they're actually looking for on that phone, that's a different pipeline entirely. It's faster, quieter, no judge in California sitting on it for hours. And here's the thing. This guy tried to shoot people at the correspondents' dinner. This is maybe the most obviously justified investigation in law enforcement history, assuming that it's an actual attempted shooting. Nobody's going to argue that the FBI should not have access to his data. Nobody. But the law that they're using, it doesn't just apply to active shooters at presidential events. It applies to you, to me, to your Aunt Martha who uses Gmail, to your kid's school that runs on Google Workspace, to every single person who stores anything on an American cloud service anywhere in the world. That's the trick with surveillance infrastructure. You build it for the monster, and then it's just there for everyone. Just another day in feral America. Today, we're talking about the Cloud Act, what it is, who it affects, and what you can actually do about it. Because last night's shooting is about to teach you something about your own privacy that you probably didn't want to learn. Buckle up. This one's a treat. Let's start at the beginning because the beginning is genuinely unhinged. The year is 2013. The NSA surveillance stuff is blowing up. Edward Snowden hasn't showed up yet, but the feds have been quietly trying to figure out how to get their hands on data that lives in foreign servers. Because, see, the old system called Mutual Legal Assistance Treaties, or MLATs, which kind of sounds like something that you might need to get a prescription for a rash. The old system was slow, bureaucratic. It could take years, not just several hours. God forbid, law enforcement has to wait. We're living in a Netflix instant stream world, and they still want to use blockbuster procedures. So they start looking for a shortcut. And here's where it gets spicy. Microsoft, yes, that Microsoft, the one responsible for the blue screen of death and the phrase, "Have you tried turning it on and off again?" Microsoft gets a warrant from the US government in 2013 asking for emails belonging to a drug trafficking suspect. Normal enough, right? Except the emails were stored on a server in Ireland, as in not America, a different country with different laws. Microsoft says, nah, you'll need to get an Irish court order for that. And the US government's like, no. And thus begins one of the most important legal battles about digital privacy that no one was talking about because we were all distracted by the ice bucket challenge. This is why we need to pay attention to what's happening when these viral things are going on. So Microsoft eventually wins in the Second Circuit Court of Appeals in 2016. The court says that a domestic warrant can't compel a company to reach overseas and grab data. That's a win. That's a good thing. Civil libertarians are doing their version of a victory dance. The case goes to Supreme Court. Everyone's watching. And then Congress passes the Cloud Act, March 2018. Tucked in a 2,200-page government spending bill, not a standalone debate, not a public hearing moment. It's just in there, sandwiched between agricultural subsidies and a provision about rural broadband. The Supreme Court case becomes moot overnight. Microsoft wins and loses simultaneously, which is very on brand for Microsoft. The Cloud Act, which stands for Clarifying Lawful Overseas Use of Data Act, in case you needed the full bureaucratic flourish, does two things, two big, sweeping, nobody asked for this things. One, it gives US law enforcement the ability to compel American tech companies, Google, Apple, Meta, Microsoft, Dropbox, whoever, to hand over your data, even if that data is stored on servers in another country. The server being in Germany doesn't matter. If it's in Japan, doesn't matter. If the company is American, they comply, period. Two, it allows the US to sign what are called executive agreements with foreign governments. These are deals that let foreign governments request data directly from American companies about their own citizens without going through their own legal courts, without the usual international legal process. Just ask nicely, have the paperwork done right, and there you go. The UK signed one, Australia signed one, and more are coming. So to recap, your data, which you may have naively assumed was protected by geography or sovereignty or the Fourth Amendment or basic human dignity, is now accessible by governments on both sides of the Atlantic, or maybe more. Cool law, guys. Really nailed it. Okay, so what does this actually mean for your life? Because I know some of this abstract stuff is a little easy to tune out. I know, I've been to policy conferences. I've seen eyes glaze over in real time. So let's say this, you use Gmail. You've been using Gmail since approximately forever because Google made it free and gave you more storage than you'd probably ever need. And slowly, over 2 decades, became so embedded in your daily existence that switching would make it feel almost like amputating a limb. Classic strategy. Well done, Google, I guess. Your Gmail is stored on Google servers. Some of those might be servers in the US, some of those might be in Europe, especially if you're European. It doesn't matter. Google is an American company, so under the Cloud Act, the US government can serve Google with a legal demand, and Google just hands over the emails. You don't get told, and technically, Google can't tell you because the demand often comes with a gag order. You just have no idea. Now, most of us, and I'm including myself here because I too have sent unhinged 2 a.m. emails about stuff I'd rather not discuss in a federal courthouse. Most of us are not drug traffickers or sex traffickers. Most of us aren't terrorists. Most of us are not the target of a government investigation. But here's the thing about surveillance infrastructure. It doesn't stay pointed at the people it was supposedly built for. It never does. That's not cynicism, that's history. Every surveillance power that has ever been created has eventually been used beyond its original scope. Every single one. So let's talk about who's actually really at risk with the Cloud Act. Journalists. If you are a reporter or an investigative researcher with sources that are stored in Gmail drafts or Signal adjacent apps that don't have real end-to-end encryption, you might have a problem. Source protection is foundational to a free press. Cloud Act demands don't care about that. Activists, especially people doing border crossing organizing, environmental groups, human rights workers, anyone whose work might annoy a government that has a Cloud Act executive agreement with the US, which is a growing list. Next, lawyers. Attorney-client privilege is a cornerstone of the legal system. But the Cloud Act could demand Google to turn over a lawyer's stored emails that doesn't automatically respect the client attorney privilege. The burden falls on you to fight the fight, if you even find out about it. Also, disproportionately affected by the Cloud Act are immigrants. If you're from a country that has or is pursuing a Cloud Act agreement with the US, your government could potentially use that pipeline to get information about you from American tech companies. You fled. You thought you were safe. Your data didn't flee with you. And look, let's give a little bit of credit where credit is technically due. The Cloud Act does include some language about human rights safeguards for those executive agreements. The foreign government is supposed to, and I'm reading from actual policy language here, robustly protect privacy and civil liberties. Robust protection from governments. The EFF, or the Electronic Frontier Foundation, which is basically like the ACLU for the internet, they've been ringing alarm bells about this since before the law passed. Their argument is straightforward. You've just created a global data sharing network between law enforcement agencies with oversights that's thin on the ground, no judicial review in the requesting country, and no notification to the person whose data just crossed several international borders. The government's argument is crime is bad and the old system was slow. Both of these things can be true, and the government can still be wrong. Hard to believe, I know. I want to just take a quick second to address what people are going to say, and someone always says this. If you've got nothing to hide, you've got nothing to fear. Okay, cool argument, very thoughtful, very 1984. The book, not the year. Well, maybe kind of both. So let me flip that for you. You have nothing to hide from your doctor, right? But you still have medical privacy. HIPAA is there for a reason. You have nothing to hide from your therapist. You share everything with them. But yet, privilege still exists between you and your therapist. You probably have nothing to hide from your spouse, I'm assuming. I don't know your life. But you still have a door on the bathroom. Privacy is not about guilt. Privacy is a structural feature of a free society. It's the thing that allows dissent to exist, to allow people to make mistakes without those mistakes becoming permanently weaponized against them. It's the thing that's allowed every whistleblower, every activist, every person who ever said, actually, wait, the government is wrong about this, to function without being immediately crushed. When you eliminate privacy because it's inconvenient for law enforcement, you don't just catch the bad guys. You also make the infrastructure available for whoever comes next. Now, I'm not going to pretend to know exactly who whoever comes next is, but I'd like to have some structural protections in place regardless. There's also this small matter of the executive agreements being negotiated by the executive branch, not Congress, not courts, the executive branch. So the same office that issues the legal demands for data is the same office that negotiates which foreign governments get to issue legal demands for data. I'm sure that's fine. I'm sure it's all fine. I'm sure there's absolutely no conflict of interest in the entity that benefits from the data access being the entity that decides who gets the data access. No notes. So, what can we actually do about this? I know I've spent the last 20 minutes making you feel bad. That's my gift. But here's the thing about the Cloud Act that's genuinely interesting from a technical standpoint. There is a structural vulnerability in it, a real one. The Cloud Act can compel a company to hand over data. What it cannot do, and what no law can do, is force a company to hand over data they don't have. That sounds obvious, I know. It is obvious. But it's also the entire ballgame. End-to-end encryption is the legal and technical answer to the Cloud Act. So here's how it works. If a service encrypts your data in a way where they can only hold the key, where even the company running the service can't read what you've sent, then when the government comes knocking, the company hands over a pile of gibberish, basically, unusable without a key that they don't have, encrypted blobs. Congress subpoenaed Signal in 2016. You remember Signal from the Pete Hegseth Signalgate? Signal is an encrypted app. The reason that Pete Hegseth's war plans got leaked was because some idiot added a journalist to their Signal chat. So it wasn't that someone accessed their Signal, it's that they invited somebody in. So back to the congressional subpoena of Signal in 2016. So all that Signal was able to hand over was the date that the account was created and the date that it last connected to the internet. That's it. 2 data points, because that was genuinely all that they had. It's not a company being uncooperative. It's a company that built a system where they structurally cannot betray you, even if they want to. That is the goal. So let's take a look at some tools that you can use that will help you protect your privacy without being too much of a drain on your time, effort, anything like that. I know we're all busy and changing your entire digital life is super annoying. So I'm going to give you the list ranked by how much effort it takes versus how much protection it buys you. So, first off, lowest effort, highest payoff, and it's free, is switching your messaging to Signal. Signal's free, it works on iPhone and Android, and it looks basically like any other messaging app. The difference is that it's end-to-end encrypted on everything. So, texts, calls, photos, videos, anything that you send through there, all that Signal can access is when you logged in. They've been legally compelled multiple times to hand over data and essentially handed nothing over because that's what they have. If you do nothing else from this episode, do this one. Get Signal, get all of your contacts on Signal. It takes a few minutes to get set up and it's free. Number 2, email. WhatsApp does end-to-end encryption, but Meta owns it and still collects your metadata. Wonder where they got the name Meta. Meta collects who you've texted, how often, when, all of that stuff through WhatsApp. And it's very much available. So for email, I would suggest switching to ProtonMail. It's end-to-end encrypted. It's based in Switzerland, and it's not subject to the Cloud Act demands. They offer free tiers, so you can get a free email account. They have a VPN as well. So it's not quite as slick as Gmail, and there are some trade-offs that you have to make when it comes to your privacy. So if it really matters, I would highly recommend Proton. Number 3 is cloud storage. Google Drive, iCloud, Dropbox, OneDrive, they're all American companies and they're all Cloud Act compliant. So if you're storing any sensitive stuff, look at Tresorit. It's a Swiss zero-known encryption company. Or you can also use Proton Drive, which comes along with ProtonMail. Next up, and I know, trust me, this is not my favorite thing, passwords. Use a password manager. Bitwarden is open source, free, zero knowledge, meaning they can't read your vault even if someone asks them to. LastPass has had breaches. I'm not going to pretend that LastPass hasn't had breaches. Use Bitwarden. Number 5, encryption on your devices. Turn on full disk encryption. On a Mac, it's File Vault. On Windows, it's BitLocker. Modern iPhones are encrypted by default when you set a PIN, so make sure to set a PIN. Android is largely the same on recent versions. This doesn't help much with the Cloud Act specifically, which is about data at rest on computer servers, but it absolutely helps if your phone is seized, lost, or stolen. You can also turn off the biometric data so they can't just hold it up to your face to open it. And then there's the general principle, which I'll call don't put things you care about in American clouds. It sounds dramatic. It's not. Do you need to store stuff that's sensitive on a Google Drive? Could it live locally, encrypted on your machine? Could you put it on an external hard drive? Maybe something that's not subject to the Cloud Act? Jurisdiction is really the word that you want to know. So you want to know where the company is headquartered, and that will determine which laws apply to your data. And I already mentioned VPNs because I know that somebody is yelling at their car speakers right now. VPNs are useful for hiding your internet traffic from your ISP and advertisers. They don't protect your stored data from Cloud Act requests. A VPN is like wearing sunglasses so that your neighbor doesn't recognize you. It's not the same as keeping your diary in a safe. They both have uses. Just know the difference. I like using a VPN for, if I want to access something that's not available in the United States. I was trying to watch a video that was in England, and I used a VPN to act like I was in England. All right. So here's the thing that I just keep coming back to with the Cloud Act and a lot of the digital surveillance infrastructure that's been quietly built over the last few years. It didn't happen because of a dramatic authoritarian pivot. There was no coup, not a single villain. There's not a bad guy that came up with this. It happened in spending bills through bureaucratic processes. It happened because most people were busy and tired, and the people who were paying attention were outgunned. And we're all living in the infrastructure that was built when we weren't looking. I'm not going to pretend like one podcast episode is going to fix this. I'm not going to tell you to call your congressman, but you can. If you want to, you can use the 5 Calls app. It wouldn't hurt, right? But what I do want to tell you is that the tools are there to protect yourself. They're free or very close to it. And the people who designed these did this so that we can protect our data. So get Signal, get ProtonMail, not because you're a criminal, not because you have something to hide, but because you're a person. And people have historically done better when they retain some control over their own inner lives. This is just another day in feral America. I'm still processing things, still apparently out loud. If you found this useful, pass it on to somebody that might also find it useful. If you found it upsetting, it's kind of the point. So again, Signal, ProtonMail. I will link in the show notes some more information about this. Let me know what you think about this in the comments. Are you concerned about your own privacy? What steps are you going to take? Are there any other apps or things out there that I missed in here? I know there's a ton. I just was giving some basics. So if you know of some other things that can help protect our data, drop a comment, let us know, and stay feral.